Welcome to Trial and Medical Error, where we bridge the gap between medicine and law and unlock groundbreaking trial techniques. Join hosts Brendan Lupetin and Greg Unatin as they share novel insights and strategies to help you confidently tackle the most complicated cases. Produced and powered by LawPods.
In today's episode of Trial and Medical Error, I interview Victor Pribanic, who is a super well-known, super accomplished trial lawyer here in Western Pennsylvania. Vic talks about a recent terrific verdict that he and his associate Sherie got in a very tough medical malpractice case in McKean County, and was, I think, the first medical malpractice verdict in that county's history. So pretty amazing outcome. And Vic shares with us his philosophy and approach to trials, the different hurdles they had to overcome in this particular trial, some curveballs that Vic and Sherie were able to take from the defense and actually turn into great pitches to hit out of the park to get an awesome verdict. Some interesting discussion on the way that Victor approaches his opening statements, his preparation for cases, cross-exams, and a particularly interesting hypothetical that he uses. So I think you'll enjoy this episode with Victor Pribanic. And for those of you who are listening who have not already subscribed, if you're liking the podcast, please subscribe on your favorite platform and give us a like or leave us a comment. We really appreciate it. So with no further ado, Victor Pribanic. All right, so psyched, Vic, to have you on the show, and we're just chit-chatting a little bit. But before we kind of launch into everything we're going to talk about today, I'm going to tell you, a little story. So when I first started practicing law, John Quinn and Irv Portnoy back in the day, I was always like an athlete. I'd always sort of want to know, who are the really good people. And I swim, and I'd always be obsessed with the top 16 in a given event. Who are the best ones out there? And so, when I tried a few cases and I got the bug for trying cases, I was always asking people who's the best in town? Who are the best trial lawyers in town? And inevitably, everybody would always put you right at the top. Oh, Vic Pribanic, you got to go. Vic Pribanic's the man. He's he's the super trial lawyer. And then I remember, but I didn't know who you were. I just heard your name a bunch. And then I remember I was trying some goofy case in Allegheny County, and I was in the middle of my trial. And I remember, you walking by, and whoever I was with was just like, "Oh, that's Vic Pribanic." You had this big briefcase and looked like $1 million. And I was, it was just cool. And so, point that out because it's neat to, 20 years for me later, get to talk to you on the podcast about an awesome verdict you had recently. So thanks for coming on and chatting with me.
Yeah, thank you for the invite.
Yeah, it's awesome. I'm psyched. So
that good anecdote.
Yeah. It's just it's neat to think about how things just kind of change over time. But can you tell me a little bit about your background? Where did you come from to go from wherever you were to the founder and longtime, kick-ass lawyer at Pribanic and Pribanic?
I began at the DA's office, Brendan. That's it. That's the only job I applied for after law school because I didn't want to, from the outset, learn how to try cases, and I thought that was the best forum to do it. And that proved to be a good choice. In a couple of years there, I tried hundreds of cases. Juries, bench trials, sometimes multiple trials in a day. So you get a rapid fire exposure to bench trials and those first few knee knocking, terrifying jury trials where you can hardly stand there and speak because I'm not naturally a gregarious sort or a public speaker, and I have the same aversions to that we all do at the outset and the same fears, and that helped get through that. And I went on to I left there, got a job as a law clerk for Judge Robert Doyle, great guy, wrote opinions for him, but not in attendance there at the courthouse. So I got a little salary and opened my own office and did primarily criminal defense work at first, some other civil things, and at some point I was representing a music group of all things in an injunction hearing, and one of them had a car crash pending in Lawrence County, and he asked, and his lawyer passed away, and he was like 2 weeks from a trial, and he asked me if I could go represent him in the trial, and I did, and got a plaintiff's verdict in that case. And I thought, well, this isn't so hard. And
It'll always be
after
like
the
that.
forums I'm used to. And then a funny story, I was doing a death penalty murder case up in Butler, Pennsylvania, and tried it once, and it was a mistrial was declared because the prosecutor got appropriately sick by the end of the case. And we tried it again, and my client was acquitted. And his brother, who was from Erie, Pennsylvania, was there watching the trial, and he had a pending, oh, what you would call a mild closed head injury case. And he asked me after the trial if I would agree to represent him in that trial, which was just in that case, which was just sitting around up there in Erie. So I went up to Erie and tried my second civil trial in front of John Boza uh, in that what proved to be a $5,000 offer case, and I got a verdict. I think was this was many years ago. Was a million seven verdict, the then biggest verdict in Erie County. So my second civil trial, and I thought, well, it's this is a much easier thing than sitting next to a guy in the courtroom with who's going to get the needle in his arm if you lose. And I started doing civil cases, became fascinated by uh, medical cases. And I went to a Catholic high school that was peopled with very bright people, and I invariably would get the highest grades in the advanced placement biology classes. I always had a penchant for it. And so I started doing more and more medical negligence cases over the years, and have tried lots of very difficult cases and lost a lot of very difficult cases and won some that some people would say are unwinnable. So it's been a great, great privilege for me to be able to do it.
Let me ask you, going back to the beginning of what you were talking about, that you mentioned something, and I'm very similar in that you said you're not a very gregarious, and maybe I sort of took from that you're not maybe like a natural public speaker, and yet you threw yourself into the DA's office to get trial work. That seems kind of incongruent to me. So what was the motivation to go from somebody who maybe wasn't loving to speak publicly, and then putting yourself in, about the most public speaking
Right.
situation you could?
I think I always had the inclination, the desire to be a trial lawyer, to try cases and to do it in that forum. And if I had to learn to, choke back my fears and embarrassments about public speaking, I was damn well going to do it, I guess.
Why did you have family that were attorneys, and this was like something you're following the footsteps of, or why did you want to be a trial lawyer?
I'm the first member of our extended family who ever graduated from college, much less having a lawyer in the mix. So there was no, family mentorship or anything like that. My dad was a very bright and articulate guy, but never did graduate from college despite spending a couple of years at Pitt. I don't know. It was just something that drew me to the trial work. I don't know exactly what it was. I just thought if I'm going to be a lawyer, I'm never going to be able to sit around in an office and, write contracts or do divorce cases or that sort of thing. Not to denigrate those or minimize them. I just knew I didn't have the constitution for it. I'm a hunter and a fisherman, and I like, that kind of thrill and that kind of skill to be in there. And in very, very important cases for our clients, as you know, and to be able to use all those. I was an English and philosophy major, oddly enough, and to use all those good words and ways of speaking that we acquire over the years, I thought it was just the best place for me to be. I don't know, it's hard to say. It was just a thing, a drive, a passion that I had from the very beginning and still have today.
I'm sure you're familiar with the epidemic, I guess is a decent term for the fact of, young lawyers have a difficult time getting trial experience these days. Do you still, to this day, think that the DA's office is as a great place for people to start? Or what are your thoughts on if somebody wants to become a trial lawyer, what's the best way to start out?
It was then a great place for me, and I think it probably still is. You can be as good or as poor a trial lawyer in the DA's office as you choose to be. I like to think that I, prepared the cases to the fullest extent possible. Had a track record there that people were beginning to take wagers when I would lose a case there, because I think I prepared more than others. I was there, late at night after everybody else had gone home, preparing for the next days or weeks or whatever. And those are habits, as you know, that there's nothing that can replace preparation for a trial. You better know it way better than the doctors do in a medical case, and the defense lawyers, and that won't always save you, but it's a threshold requirement.
I think I'm always fascinated that really good trial lawyers come from all walks of life and different influences, different backgrounds, and different ways that they kind of came up. I did not do the DA route. Wish I had. I think I would have gotten even more trial experience. But having not done that, and did everybody in your firm, at least all your family members, did they all start out in the DA?
My brother Michael did. Jeffrey did briefly. Ernest not. He's been tutored by me for the most part. That's as far as today. How do you get trial experience? I would imagine that's still as good a forum as any today. And like I said, you can learn great habits there, or you can learn bad ones. Just the same thing with the public defender's office. You can get prepared, or you can go in and do a lackadaisical job and not learn anything. But if you want to learn how to try cases, you obviously have to be in a courtroom to do it. And that's the only place that I know that ensures that.
Do you feel that your time in the DA's office, I mean, it's this, relatively short period of time, but very high density exposure to trial. That had to have influenced the way that you approach trial or the way you think about trial? I mean, I have to imagine it's got to be somewhat different than the way, me, who never went through the DA's office, approaches trial. How do you think it impacts the way, you look at and handle civil cases?
I think what it does is I started there and then did a great deal of criminal defense, including, like I said, the death penalty cases, very, very serious criminal cases, probably a dozen or so in federal court, which is the worst possible form to defend a person in a criminal case around. And I had a almost completely 100% trial win record in the federal courts, which is, if you know anything about that place, is really, really remarkable. And you get to, you have to learn to think on your feet and react and be able to deal with an unpopular form. Many federal judges look at the defense lawyers, I think, as not being very far above the defendants. It can be a very, very, very unfriendly place to be, and you have to be able to push through all of that, and you have to be able to react to bad things that happen during trials with a certain amount of poise and creativity. And you really have to be tough and learn to swim against the current, if you will. So I think criminal defense, I've always said I can try any case, whether it's a civil case, a criminal case, or whatever, with the basic skills of being a trial lawyer. It's not, you can learn any case, you can learn medicine, you can learn, you know, rules and regulations for tractor trailers, you can learn, patents or trademarks if you have to. It's the basic fundamental skills of how to talk to judges or juries in particular. They transfer across the board, I think.
Do you have, specific to civil cases, we've got the burden of proof, albeit it's a lower one than the prosecution in a criminal case.
So they say.
It doesn't work out that way. They say it. I still think you have to prove it by, beyond a reasonable doubt in our cases anyway. But do you have any sort of, big picture principles? Like when you're talking about, if you're a trial lawyer and you have, those overall trial abilities, you can try any case. I mean, are there any kind of big picture concepts that you feel, basically apply in every case? I mean, whether it's, connecting with the jury, talking with the jury, keeping the trial short or long, or what do you, what are the big picture aspects that you think apply always?
For me, the biggest thing is to believe in the case, to believe in the client, to believe we're on the right side. I have that sort of maybe some metaphysical belief that if you don't believe what you're saying and you're not really behind what you're saying, you can't be persuasive. And part of that concept is that you must always, always tell the complete truth to a jury or a judge, as we all know. But it's a rule that I think I see abridged from time to time by lawyers, and it never ever ought to be. I tell my brothers all the time that as a lawyer, if you can't be truthful about things, and most especially always in a courtroom, you shouldn't be doing it. And if I get myself in the mental space where I'm convinced I'm on the right side of the case, that I could tell the jury the truth about the case and what happened and why it ought not to have happened, as the case may be, then I think you go a long way towards becoming your most persuasive, articulate self. I believe people feel that, that when you're talking to a jury, I think they can feel, the passion and belief that you have. I mean, I think it's not words, it's not communication, but it's some connection that you can make.
On that point, and we're going to get to the Wolfgang case, which is, a big part of what I wanted to talk to you about. But with those ideas in mind about, the belief in it, and I feel the same way. I imagine sometimes we are sort of selling something. We are definitely selling something in trial, but I imagine sometimes if I had to stop being a trial lawyer and I had to go into some other occupation, and I think of, sales, you'd have to believe in the product, or else I don't think I could ever really sell it to somebody. I'd feel bad about it. They'd read it on my face, kind of thing. And you talked earlier about the importance of preparation. Now, with all that said, I think there's, been not a movement, but I think there's a lot of discussion about, and I talked with a really good trial lawyer a couple episodes, and they were talking about how they really try to script out the entire case. The opening is, to the word, like almost written out, and the images are written out, and everything is very, almost like a play. Now, I don't think that always works out that way. Now that said, are you that, sort of, mechanical about it, or do you take a sort of a looser approach, obviously still having prepared heavily for the case?
I would be fibbing if I had ever said I ever completely scripted out a whole trial. I don't do that. As far as openings and closings in this luxurious era of being able to use PowerPoints, speaking from a vantage point where it was just your words and a card or blown up exhibit that you could use in an opening or closing. They are an immense help as for persuasion and an immense help as a mnemonic device for doing openings and closings. They're not something you can rely on exclusively, but if you're very, very careful and prepare a good, bare bones PowerPoint for an opening or closing, it can result in a really, the kind of opening you sit down after you're done and think, man, I have really gone a long way towards winning that case right now, right now. And as my early mentor, Jerry Spence, always said, when do you want to win your case? And he says, as soon as you can. And that's the opening. And I don't believe for any minute, for a moment, that you could absolutely win a case in an opening, but you sure as hell could take a long, long step towards that.
Did you ever meet Spence?
I have, yeah, as a matter of fact, yeah.
Okay, that's really interesting. Regarding your openings, do you typically have sort of a set formula you follow, or a sort of a pattern, or is it really case dependent?
It's kind of case dependent, but like all of us, like I know you do, Brendan, I've been a student of the great trial lawyers across the country and the world, from reading Clarence Darrow's openings and closings on up to the geniuses out there today. And I shamelessly steal and borrow things and phrases and methodologies and put them into the sack and shake them up and come up with my own formula. But I've been a great fan of and it's sometimes at odds with David Ball and his group, but I still use very often a simple rule at the beginning of a medical negligence case. Doctors should never unreasonably endanger patients, and it gives you a sort of touchstone to work through cases with. And but I do not use that formulaic opening template that is touted in those books. But notwithstanding, there's a lot of good things in all of the publications today. The direct exams and the cross exams. Obviously, nobody, I don't care what you tell me, nobody can thoroughly script a cross exam and get away with it.
No, agreed. And unlike you, who didn't get the, I don't know if you had somebody mentoring you when you were in the DA's office, but I was just sort of left to my own devices and tried any case I could get my hands on at my old office. And, I just was like, I got to figure out something, if there's something out there. And I just found books and read the books. And I think because I was basically book taught, combined with then trying it out in trial, I'm probably a little more formulaic than probably you would be, based on our different backgrounds and so forth. And I did not have, I think I lost my first, 12, 13 trials before I got, my first verdict was $500. So a different starting point than you. But I'm jealous. I'm jealous.
The difference had been that I tried many, many cases by the time I tried my first civil cases, and the basic fundamental rules of trying cases were already there. So
yeah.
So I had a leg up, if you will.
This is true, 100%. So let's talk about this awesome verdict that you and how do you pronounce Sherie's last name? Is it Cannin?
Yeah, Sherie Cannin.
Sherie Cannin. Okay. So you and Sherie tried a med mal in McKean County, which for those listening who are not familiar with the Commonwealth of Pennsylvania and the outlying counties. There are certain places that you do not want to be if you could avoid it, but you can't control where people get injured, unfortunately. And so you're out in McKean, which is not a very good historically plaintiff venue. Is that correct?
As the judge told me more than once, to the point where I at the end made a remark maybe I shouldn't have. He told me again and again and again, there has never been a plaintiff's verdict in a medical malpractice case in our county, in the entire history of the county, to my knowledge. I don't know whether that's true or not, but he told me that again and again. And right before the trial, Brendan, he said that yet again. And I said, well, Your Honor, it sure sounds like you're due for a verdict up here.
That's awesome. And then you do it. I mean, it doesn't get any better than that. So I know a little bit about the case, but can you give us sort of a summary about what it involved, and what were why did you guys bring the claim? And then, of course, if it tries, there's obviously some issues with the case, and talk about the problems with the case as well.
Okay. Well, our client, Randy Wolfgang, had lost his left leg below the knee from an undiagnosed infection in his foot. The looks simple on his face, but Randy had, who was then and still is, as far as I know, even in spite of my remonstrations against him, was a heavy smoker, had bad vascular disease, and he had developed an abdominal aortic aneurysm that was repaired some years before this infection occurred in his foot. And what proved to be the cause of his foot infection was the graft in his belly got infected and was showering bacteria down into his extremities, including his left and right foot. The infection in the left foot got bad enough that it cost him his leg. And with that kind of complex overlay, none of our experts in the case, and the defense certainly was screaming the whole trial that nobody could have diagnosed this infected graft and therefore cured the foot. Very complicated, messy sort of medical matrix. And we have a client who's a smoker, which, is anathema to some people, some juries, and you always have to hear about it from the defense experts and the like. So it had, it had issues, and one of the Sherie Cannin, God bless her, I tell her she should have been a defense lawyer. She, even to the point of driving to the courthouse, she said, I don't know how we could possibly win this case because he should have gone to the emergency room over the Thanksgiving weekend when his foot got so bad, and we can't win. And that, as you know, is a kind of a bad problem in a case.
Absolutely. And wait, was he diabetic as well?
No, not diabetic. One good thing.
I was like, how many medical problems can you have in one case? I mean, the smoking is very difficult to overcome because it becomes the drumbeat of the defense, and there's some legitimacy to it. It can, there's studies out there that show it can impact healing and all this different stuff. So that's a formidable hurdle. But what was it about? Because in the article that I read, I understand there were some concerns about a comparative component. So what was the time frame? So he develops this infection on his foot. And so what's the time frame from time of infection until it gets to the point that he's got to have his leg amputated?
Several weeks. In the interim, he'd gone to the emergency room twice and seen his PCP once, been given antibiotics and a variety of things. And our salvation, Brendan, on that subject was that the wife had made phone calls that were, some of which were documented at least, to the PCP's office over the Thanksgiving weekend. But most importantly, I had a really good vascular surgery expert from up at Brown by the name of Dr. Patterson, who looked at the photographs that the wife had taken of his foot, and he developed this abscess in his left foot that bloomed into a pustule on top, the dorsal side of his foot, the top of his left foot, over the Thanksgiving weekend. And Dr. Patterson said, look, by then, that foot was gone. He had osteomyelitis in there. The bones were destroyed. And sure enough, there was a CT scan done the Monday after Thanksgiving that did show that the bones were, dissolving at that point. So whatever he did or did not do over the Thanksgiving weekend was of no consequence. And even the PCP, I think, trying to deflect responsibility from himself for not being more attentive to the phone call, said, "Oh, it was too late by then." So that worked out famously for us.
And so by the fact of, the point of no return happening before your client's alleged, comparative actions, that was your primary defense for why he wasn't at fault or contributed to this, because it was already, the die was cast, so to speak.
Yeah, and his wife was very assertive. Not him so much because he was in terrible pain lying on the couch, with a dreadful infection. But his wife was very assertive about calling the PCP and explaining that his foot still wasn't any better, and no action was taken. So that was very helpful.
So what were the primary theories of fault against? I understand there was two defendants that what was it, a 90-10 apportionment of fault between them?
Yeah.
What were the theories of fault against both of them?
Well, the ER doctor for failing to do an adequate exam, failing to do adequate testing. An example of how poorly this fellow was treated would be that I think the last expert for the defense, Brendan, was a professor from Penn, internal medicine, whose name escapes me at the moment, but he was up on the witness stand, and I asked him, I said on the voir dire, I said, "So you're a professor?" And he said, "Yes." And a doctor too. He said, "Yes." And I said, "And you teach young men and women how to be good, safe doctors and to treat their patients so they're safe and don't get harmed?" "Yes." And that's all I had on voir dire. And then one of the defense lawyers, maybe you'll know who it is, even likes to use slides to talk about the doctor's duties on them. And I prepared a slide for Doctor, I think his name was Mink, and I said, these are the duties that I'm going to ask you about some duties that this is on cross-examination now, that the doctor had. And I went through this list of things that were, no-brainers that he had to say yes to: perform a good, thorough exam of Randy's left foot, obtain complete medical history, and so on. Everybody had to agree to it. It became apparent, I think, in going through this list of duties to the jurors, that much of this had not been done. And then for some fun, the last witness in the case, I said, "Dr. Mink, I'm going to ask you, since His Honor," and the judge had been very diligent about informing the jurors about what and who an expert witness is and how they can and must answer hypothetical questions. And I said, "I'm going to ask you a hypothetical question, since His Honor has told the jurors in this case we're allowed to do that." And he said, "Okay." And I said, "Dr. Mink, I want you to assume that I have a bunch of bird dogs. I have a bunch of English setter dogs, and I take them hunting. And sometimes I go hunting right up on the mountain here in Claremont for grouse here in Pennsylvania." And he said, "Well, I don't know, why or how talking about a dog could have anything to do with this case." And I said, "You'll see." And I said, "I want you to assume that one of my dogs," and I said, "I'm going to select my dog, whose name is Pity Pat, true story, Pity Pat, as the example here." And I looked over my shoulder and I said, so the defense lawyers can make fun of me later on." And sure enough, one of them did. And I said, "I want you to assume that Pity Pat comes around the bush, and just like Mr. Wolfgang, she can't put weight on her left front leg. And further assume that I'm going to lay her on her side, and I'm going to push on her shoulder and her elbow and her wrist to see if I can elicit pain." And I said, she'll never bite me, but she might lick me if I'm hurting her. And then if none of that elicited pain, I'm going to take her foot, and I'm going to start pushing on the pads of her foot hard, so I can see what's hurting her. And if it was something like what was bothering Randy Wolfgang, she would wince when I pressed on her foot. So I would take her to the vets and they would do an x-ray. And first I stopped there and I said, now, Dr. Mink, uh, that exam that I would do on Pity Pat in the woods. Now, Randy Wolfgang was entitled to at least that good an exam of his foot, wasn't he? And he said, yes, he was. And I said, did he ever get one from the emergency room doctor, the emergency room physician's assistant, or the PCP? And he turned red and he said, well, it was never documented. I mean, this poor man had come in unable to bear weight on his left leg, and nobody did a simple thing like find out where it's hurting him: knee, calf, foot, whatever. I mean, his foot was red and swollen, but presumptively that's what it was. But so I said, to continue with our analogy, Dr. Mink, when I take Pity Pat to the vets, they're going to x-ray the foot to see if there's a broken bone. He goes, uh-huh. And if that didn't show anything, they're going to do an ultrasound to see if there's a soft tissue thing in there that's hurting her. Uh-huh. Okay. And if none of that revealed anything, they'd say, Mr. Pribanic, would you pay for a CT scan of Pity Pat's foot to see what's going on in there? And you can bet I would have agreed to pay for it. And they would have diagnosed her problem way before she lost her foot. And I said, did they do those tests for Randy Wolfgang until it was too late? He said, well, no, and it was just a perfect kind of simple analogy that made it very, very clear. And I was, I was a little troubled by it, but the judge didn't really like me that much. And I thought, well, maybe I'm going to get jumped over this, but I didn't. And sure enough, in the closing argument on that Pity Pat cross examination, one of the defense lawyers had to mock me like I knew one of them would, and said, and we had to hear about Mr. Pribanic's dog Pity Pat. I don't know what that had to do with anything. And I got a call from a juror a couple weeks after the trial, a lady who was a commercial insurance salesperson, one of the more conservative people on the jury. And I said, "Boy, I hope it didn't bother you me talking about my dog Pity Pat during the trial." And she said, "Oh, no, no, that was perfect." She said, "It became very apparent to us that poor man got treated worse than a dog."
Yeah, and that was the take. I mean, it's brilliant to me when you compare that, and it's you're not even saying it, but the implication that they picked up on was this guy didn't, a dog would have gotten better care than what he got under the circumstances.
And that would be insulting to say that, but I was using her as an analogy, and it worked well. It was the truth too. I mean, it was the truth. I remember vividly during the closing argument. And I don't know whether it's proper or not, Brendan, but I raised my hand like this and I said, "I swear to God, ladies and gentlemen, if that had happened to Pity Pat, she would not have lost her leg."
That's great. It's not violating the golden rule if it's applied to a dog, right?
No, I don't think so at all.
So obviously that was a really compelling cross that did connect with the jury. Were there any other? Well, let me ask you this: when you're going into closing, I'm sure you've had trials where you're feeling like things are just rolling with you, and you just have a very good feeling you're going to win, and other ones kind of don't know, and other ones you're pretty sure you're done for. Where were you going into, say, closing and deliberations? Did you feel like you had it, or were you uncertain?
What I felt like is that I had tried the best possible case that I could have tried, and I was happy with the way things went, and I was at that blissful state that you don't get to very often in a trial, where I was just confident that everything had gone as well as it could have for our client, and very, very hopeful. Not confident. I don't know if I ever really believed this is in the bag or that sort of thing, but I felt great. I mean, I felt like I had done it all as well as I knew how. And it was one of those things. I was telling somebody afterwards, I'm gratified to see that after all the years I've been doing this, I still think I get a little bit better each time I do it. and I've never had the feeling of backsliding or losing my touch or my passion for it or anything like that, which is a great thing for you to look forward to, Brendan.
Yeah, no, I do because I really feel like I have so much to improve upon and get better
Right.
on. So I love hearing that you're feeling that as well. Given all that you've accomplished. A bunch of other questions I want to hit you with. So going into the trial, what were you most worried about as far as like where I like to think, some other, great trial lawyer said somewhere, it's like, inverse and flip the case. And I try to think about, okay, not how am I going to win the case, but how do we lose this case? What's the most likely way we lose, or why are we going to lose this case? Where were you feeling most concerned that you're going to lose that case going in?
My biggest concern was the perennial attempt by the defense to play to the human being's lowest common denominator of, prejudice. The guy smokes, he still smokes, he lost his leg, he's got all these other health issues, all that sort of jazz. He didn't go to the ER, all that often irrelevant stuff that they try to smear people with. That was the biggest concern that I had going into it. But the one great thing, and I got to give the judge credit for this. One great thing he did is he allowed us to submit voir dire questions beforehand, some read by the court, and then he brought panels of three of the jurors into one of the little conference rooms or whatever, and he allowed us very progressively, the lawyers, to get up and do just a little bit of individual voir dire with the jurors. We had to stick to the script, but being who I am, I had to ad lib a little bit when I was reading the questions. And we had a question about smoking, and I put it to the prospective jurors, uh, you're going to learn during the trial that Randy Wolfgang is a smoker. And there are people, and this wasn't really in the question, but there are people who think that, if you eat too much, or you drink too much, or you eat too much candy, or you smoke cigarettes. I tried to blend it into things that everybody does or knows people who do, that we all know are bad for our health. Does anybody feel like the fact that he did smoke, and he still does smoke even today? I told him not to smoke around the courthouse, but he still smokes today. Does anybody feel like that would interfere with their ability to act as a juror in this case? And we had a couple people stricken for cause on that question, and a couple very nice people said. I remember one little old gal said, "Well, our people don't smoke, but I don't have anything against it. If he wants to do it, that's okay." And it was a kind of affirmation that they were going to be fair. That was really great. And I had another question that I'm trying to find it, printed them up because I have a memory like a bathtub here, that was directed to his, diagnosing himself, taking himself to the emergency room, that sort of thing. And it was, does anyone feel that even though a patient has seen multiple doctors and has been given medications and advice, that the patient cannot or should not rely upon the doctors and should instead be responsible for diagnosing and treating themselves? And one of the defense lawyers popped up when I read that question and began objecting. That's an improper question. And I said, well, Your Honor, I submitted it months in advance and it wasn't objected to, and the judge ruled our way. And that question, that voir dire question, proved to be a very good one because it got the people, there's three of them now, and there are three prospective jurors, got a little dialogue going between, well, yeah, I think you have to rely on the doctors. And there were a few that said stuff like, no, I think it's always your responsibility, and you can weed out the bad ones. So that forward looking a little bit of individual voir dire gave us a huge leg up in coming up with a jury that was fair, I think.
That's an interesting. That's the crazy part about Pennsylvania, where every county is different, and
Yeah.
every judge within the county is different in the way that they conduct voir dire and run their trials and so forth. I've never heard that variation yet, of three people at a time and kind of individualized voir dire. So
It was great, and I applaud him for doing that because it like I said, it went a long way towards allowing us to get a decent jury.
So, Vic, you tried the case with Sherie. How did you guys divvy up, work throughout the case? And do you typically try cases as a team or with someone else, or are you more into, try case on your own or a mix?
For many, 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 many years, up until this past year, I tried virtually every single case exclusively by myself. Last October, we tried a birth injury case up in Mercer County, and my brother Ernest went up, and Phil Chapman from our office went up. We split up different witnesses, and it was great. It was good for the case, good for the client. A lot of fun. We had a great time doing it, and I became a believer after that, belatedly in my life, that that younger lawyers, somewhat less experienced lawyers, have a lot to add to trials, and that's how they learn. And so, my habit forevermore will be to have one or more of the other lawyers from the office in on trials. I just think it works better, and it allows the kind of good guy, bad guy sort of thing a little bit. You can have one demonic plaintiff's lawyer cross-examining the defense experts, and a nice woman like Sherie Cannin, lawyer, doing the direct exam of Mrs. Wolfgang, which she did in our case. And Sherie, I think you probably met her. A very sweet, lovely, brilliant woman who made and they just women sometimes get along better with women in a trial. I don't know why, and that worked very well. So that's my spin on it. My eyes have been opened.
Yeah, I mean, I'm very similar. I mean, not necessarily by choice, but I tried, I don't know, first 25 of my trials by myself, and then came over to my current firm and tried a case with Greg, and we got a great verdict on it. And it was so much more enjoyable trying a case
Yeah.
with someone else.
Hmm.
And then, and I've mostly tried cases since then with Greg. And then more recently, I tried one with Maggie, who's, phenomenal associate in our office. And yeah, everything you just said, it was, she had really insightful takes on the case that I had not thought of, at different, just kind of touch, I think, in like with
Yeah.
witnesses and and that sort of thing. And I think sometimes I can get a little, sort of like you said, the demonic cross examiner. Sometimes you can get kind of carried away, and it's
Yeah.
good to kind of have somebody there to either check your, help check yourself, or they're just providing that overall balance to your team's trial presentation. So yeah, I feel very similar to the way that you do about that.
Yeah. That trial in October, my brother Ernest, I was cross-examining the maternal fetal medicine expert for the defense, and I did exactly that. I got a little bit, been a long trial, stressful. For a couple of minutes, I was a little bit over the top and raised my voice, and I was polite, but I raised my voice, and it was stern, and Ernest said to me, he said, "Boy, oh boy," he said, "for a couple of minutes, man, you were over the top there." And the defense lawyer, I remember in the closing in that case, lamented to the jurors. He said, "Mr. Doctor So and so was just here trying to help, and he took a beating from Mr. Pribanic. He took a beating." He said he hollered at him from over here, he hollered at him from over there, and never a good idea. I survived that episode, but never a good idea. And it goes to your point that having a second set of eyes and a brain in the courtroom to pull you back a little bit is helpful. Too late for that, no harm done.
Um, so what was the verdict in the McKean case, in the Wolfgang case?
The verdict was 3.25 million. 99% on the defendants. 1%, I think, was more like a slap in the face to the defense by the
Right.
jury on Mr. Wolfgang for God knows what. But that was the verdict, and it was, certainly the largest verdict in the history of that county. Maybe the only one in the medical case. I don't know, but
How did it break down?
it was like 90% to the PCP, 10%, 9% or whatever to the ER doctor, and 1% to Mr. Wolfgang.
What was there? I mean, was there? It was all pain and suffering, right? All non-economic.
Yeah, yeah. We had a life care plan for the, prosthetic and all that stuff for the artificial limb, but I didn't even put it in.
What was the number? Do you remember what that number was?
It might have been 100 or 200,000.
Yeah.
It was not anything that to me warranted the trouble, or, I thought I'd be a lot better off talking about who Randy was and how this affected him than, talking about nickels and dimes for socks for prostheses.
And what was there a breakdown between past and future pain and suffering?
Uh, if there, let me see if I can
Or was it just a single line number? Do you remember?
hang on. I'll check for you. So it was 10%, 89%, 1%, and past non-economic loss 1 million, and future non-economic loss is 2.25.
And how old was it Randy? Did you say Randy Wolfgang?
Yeah,
How old was Randy?
66 at the time of these events.
So I mean, I'm probably wasting a lot of time in my life, but whenever I've had verdicts like that of all pain and suffering, and they come up with some number in a one of the 3 states, I think, the entire United States, where we can't ask or suggest a specific number. What do you think drove that number? Where do they get those figures from, if you had to guess?
Oh, I think a lot of it has to do with their perception of the client, and this is another fascinating part about this trial. One of the other observations my defense lawyer oriented colleague Sherie Cannin made over the years, she said, he doesn't even complain. There's nothing, you ask him, does your having an artificial leg bother you, Randy? He said, no, I don't skip a beat. He's a janitor at a grade school up there, and, runs those big machines, pushing them across the floor, and does all that hard work and drags that heavy leg of his around. Never skips a beat, smiling the whole time, happy as he can be, just keeps on plugging. A real tough son of a gun with a good disposition. And what do you do with a guy like that in an injury trial where, I mean, you're not going to get sympathy for how horrible his life is, in a direct way. You can't have him get up there and whine. That's not who he is. So his entire direct examination, Brendan, was maybe 20 minutes, and
Okay.
it consisted of me, kind of having fun with Randy and talking about what happened to him, and and I said, I used, and I spent a lot of time with him in his house, and all those things that we must do to get to know our clients a little bit. And I said, what were you doing before you got your prosthetic leg? He said, well, a friend of mine gave me one of those electric carts, and we'd had a big storm, so I was going around the yard and had a chainsaw. I was cutting down the trees that had been knocked over and got those all done. And I said, well, what about your garden? Because I knew he had a big garden, because I was up there in this little lane up in Smethport. And he said, well, before I got my leg, I had to go out there, and crawl along the rows. And he's laughing at himself. But at the same time, he's a hero for doing this stuff. And he's not crying about it. But the jurors are seeing that this son of a gun, has really been hurt, not by me telling him that or him telling him that, but just by inference, if you will. And I said, well, tell us what happened the next year, whenever you got your artificial leg and you were working at the garden. He starts laughing, and he said, well, I was out there planting, and my leg got stuck in the mud, and I was spinning around out there, and I had to call Stacy, and she came out and she started laughing at me. and I had to pull my leg out of the artificial leg, and I fell over, and we were both on the ground laughing about it. I had to pull it out of the mud and put it back on. The jurors were kind of laughing too, but at the same time saying, "Gee, Zooey, this guy had to put up in the lot." And and I asked him, I said, "What do you do whenever you have to go to the bathroom in the middle of the night? Because at your age, maybe you have to do that once in a while." He said, "Well, I have to get up and put the leg on and, put the socks on it and all that." And he said, "The other thing, when I get in the shower," he goes, "I have to sit down," because he didn't have a waterproof prosthesis or anything. "And I have to sit down." And he said, "Man, if that water gets too cold or too hot, you're really in trouble because you're sitting there." And he's laughing about it the whole time. And the jurors, you could see they loved the guy. And and then I asked him, and I didn't know how to, I don't think there's anything wrong with this. I think it's kind of a given. I said, but I put it to him. I said, "Randy, would you be embarrassed if I asked you to come and sit down in front of the jurors on a chair and take your leg off and show us what you have to do that? You've been bragging to me, and Randy, or your wife's been bragging to me about how quickly you can do it. Now let's show us with the court's permission." I said, "Your Honor, would you sit down and do that?" So I got a chair for him, and he came and sat down, and the jurors were all standing up, peering over, looking at as was the judge, looking at what he had to peel off and the different layers of socks and all that stuff. And he put it back on, and it was just you see these books today, you've probably read them about, jurors not wanting to help people that are helpless or dead or gone, or, are never really going to do them any good.
Right.
And
hopeful rather than hopeless, right?
Yeah, he was a classic example of a guy who, one of the jurors said to me afterwards, she said, he just wanted to get back to work. And that same gal who had talked to me about pity pats said to me, I was very concerned about those conservative jurors in Smethport not coming up with enough money for that man. So I figured I'd start out low, about $1 million, and see if I can work them up from there. And she said, when I proposed that, she said, those old ladies on the jury said to me, "Oh, no, that's not enough money for that poor man."
That's awesome. Did she give you any insight on like how they arrived at 3.25, or was it just kind of, random numbers get thrown out there? They knew it was, $1 million type case, and they just kind of picked something arbitrary.
I don't really have any insight on the minutia of that. It was, I guess in these times, people know what cases go for, even in Smethport, and I guess they just thought that was the right thing to do.
So, Vic, we're coming up on the hour point, which is usually where I like to keep these interviews, but I have last sort of area I want to talk to you about, which is one I've been wrestling a lot with. So you had a case here where, I mean, the defendants were individual doctors for the most part, right?
The hospital as well, the ER doctor, yeah.
But was it the ER doctor that was kind of the focus, or was it the hospital as the employer of them?
Both.
Okay.
I would say, yeah.
And where I'm going with this is, maybe selfishly because I do mostly medical malpractice, but I think the hardest cases for a plaintiff to win are cases against individual doctors. You know what I mean? It's not a system failure case. It's not a corporate case. Generally speaking, doctors are trying to help. They didn't mean to hurt this patient, even if they were, grossly negligent.
Right.
How do you, in opening or the way that maybe it's a cross-exam of the defendant, how do you, deal with that sort of, there's going to be that natural kind of, typically a kind of a natural fondness that the jury's going to have for the doctor. They're going to hold the doctor in high regard. I mean, do you have any specific, argument that you make on that point, or not necessarily? Don't get too caught up on it.
Well, if that's where you are, you can't get too caught up on it. I mean, if you only have an individual defendant in a case, that's what you have to deal with. As far as whether it's hard or easy, hospital versus doc. Obviously, the hospital, like the trucking company, is way better as a defendant than an individual physician. But that, I think that has to come out. That their fate is usually in their hands, Brendan. I think if they're, individual doctors, I think sink or swim based on how they behave on the witness stand, in my experience. If you get a guy up there who's really a sweet guy and, laments what happened, and instead of this, trying to fib and go around it, and, they hang themselves almost every time. And that's what I have to depend upon. And, these days doing depositions beforehand, we have a pretty good flavor for where they're going to go. And with that, you have to be deadly polite and always polite to those individual doctors. You can't be heavy handed with them. But there's a way where they reveal what happened. I mean, I think once they get caught in a lie, which I caught all the doctors in this case and many, I think their fate is sealed. Once if they were on the right side, they do not have to do that.
Okay. Do you have anything? Because what I'm thinking about is, I typically take a rules-based approach and, tell the story and focusing on the actions of the defendant and so forth. But I've been thinking more about, like you said earlier, the importance of, being truthful with the
Right.
jury, and trying to meet the jury even more kind of where they are regarding, look, like this case is not a referendum on whether this doctor is a bad person or a bad doctor overall, or that they even meant to hurt this patient. In fact, I would bet that if the doctor had to do everything, they wouldn't want this to happen. They probably feel bad about it,
I
but,
always say that myself. I always make it a point, usually in the opening, to explain to the jurors that they're not here to judge the guy's entire life or his moral worth or his quality as a doctor, but the evidence is going to show beyond any doubt in this case that in this case a terrible error was made, a negligent error, and hurt his client, whatever.
okay.
Sometimes, like I said, I think mostly they're responsible for their own fates in these trials. The Dr. Lamoth, the ER doctor in our case, had an expert, Dr. Rebecki, in case you ever run into him, who came in on Friday afternoon and who had written a report that said that they changed Mr. Wolfgang's antibiotic from Augmentin to clindamycin, and it's all over his report multiple times. Every defense report in the case changed the antibiotic from Augmentin to clindamycin. He comes in on Friday afternoon and he says, Dr. Lamoth added, and I heard it was actually a question from his lawyer, Brendan. Did Dr. Lamoth add clindamycin to the antibiotic regimen? I'm thinking, I got a major issue coming up here. And sure enough, he said, yes, he added clindamycin to the Augmentin regimen. And there was a document, a nurse's note in the chart that said Randy had left his Augmentin at the hospital, that they called him to come and pick it up, and after 3 days, they threw it away. And so Dr. Rebecki, contrary to what's in his report, said he was supposed to keep taking both antibiotics. And if he had done that, it probably would have saved his leg. So all on Randy for being reckless and negligent and not coming back to the hospital and picking up his Augmentin that he was supposed to take along with his clindamycin. Complete fabrication, absolutely complete fabrication. And here it is, Friday afternoon, after a good weekend trial, and I'm thinking, oh shit, this is really going to be a mess. And I thought there has to be some document somewhere. And Sherie Cannin, God bless her, is the most meticulous custodian of records and whatnot. Over the weekend, she finds not in anything produced by the hospital, shockingly, but she finds medication discharge instructions printed up at the hospital, signed by Dr. Lamoth, that tells him what to do about his medicines at his second ER visit. First one, he was given Augmentin. Second one, clindamycin. says, plain as day, Brendan, stop taking these medicines, Augmentin. Begin taking these medicines, clindamycin, signed by the defendant P. Henry Lamoth.
Thank God, right?
Yeah, right. Who gets up on the witness stand Monday morning and proceeds to tell the jurors how he had added, I still couldn't believe he was going to do this. He had added the clindamycin to the Augmentin regimen, and he wanted the double antibiotic coverage and all this jazz. And embellishes this tale that clearly was false. And I had a PowerPoint prepared with that form, and I put it up on the screen, and the defense lawyer began to say, we don't have that document, and blah, blah, blah. And I had Sherie check over the weekend, and we had produced it to them, and apparently they neglected to ever look at what we gave them. But
Meanwhile, wasn't it their record?
Yeah, right. It wasn't a record. And the judge said, well, you better have given that to the defense. I said, Your Honor, it's their record. It's a Braddock Hospital record. How can it be my responsibility to do that? But we had in any event.
Sure.
And you could tell the judge was laying for me, Brendan.
Yeah, right.
I had produced that. It was going to be an ugly event for me, but they checked their records and abashedly said the following morning that they had it. It was just overlooked. But anyhow, a couple of hard lessons there. But I asked the Dr. Lamoth, and I used one of my old lines from an old thing I used to do in a criminal defense case once in a while. I said, Do you know what the word mendacity means, Dr. Lamoth? And he said, no. I said, well, it's about not telling the truth. I said, I don't want to call anybody a liar to their face. It's impolite. My mother always cautioned me against that. But would you tell the members of this, before I showed them the form, I said, would you tell the members of the jury whether that story about adding clindamycin to Augmentin was one that was laden with mendacity, Dr. Lamoth? And he said, absolutely not. And then I put the form up and showed him. He said, I've never seen that form before. I deny that it was just horrible for them,
I mean, but is that not, those are the greatest moments in trial, right? I mean, that you live and you'll never forget that moment. I mean, those are the greatest moments when you catch somebody and you're able to expose something like that.
Yeah, this trial had a lot of those, thankfully, but and I had that willful falseness jury charge as part of my closing to emphasize, and the silly PCP. When he was showed the form, he testified after, the ER guy. When he was showed the form, he said, I've never seen a form like that before. I don't know what that, he put himself in the same boat.
For no reason.
Yeah.
Yeah, that's great. I mean, I love hearing stories like that, and those are the things that make me the most fired up to keep doing it. So, well, Vic, this has been awesome. I've gotten a ton out of this, learned a lot from you. I know, we both have tough trials coming up in January, so I wish you the best of luck with yours. And I appreciate you doing this, man. I got a lot out of it, and it was just really enjoyable for me. So thanks for your time, man.
Thank you.
So if anybody wants to get a hold of the great Victor Pribanic, you can find them at Pribanic and Pribanic all over online. Just search great PA medical malpractice lawyers, and Vic's face will pop right up. And Vic, I'll do a read on and everything, give you a more proper introduction before this. But thanks again for doing this, and just hang on a second. We're gonna buzz off, and thanks everybody for listening to the podcast again.
Thank you, Brent.
Thanks for tuning in to Trial and Medical Error. We hope our discussions have equipped you with actionable insights to lift your clients above the hurdles of medical malpractice litigation. Ready to refer or collaborate on med-mal and catastrophic injury cases? Visit our attorney referral page at pamedmal.com/refer. See you in the next episode.